Ivanka Trump may have thought that deleting her messages would make them go away for good. But things have changed in her legal situation. A court monitor found a large money transfer of about $45 million to a new company she's set up in Delaware. This looked suspicious to investigators. Her lawyers said the paperwork was fine and everything seemed legal on the surface. They believed that without clear proof of trying to hide money, she could avoid serious trouble. Now, New York Attorney General Letitia James has taken strong steps. In recent days, the judge in the case allowed special powers for gathering electronic evidence. Legal experts say this is unusual in a civil case like this. The office got court approval to send strong requests to big tech companies. These include Apple, phone companies like AT&T and Verizon, and apps like Signal and WhatsApp. The goal is to get Ivanka's personal messages, even ones she deleted, from the time when that $45 million move happened. Investigators say Ivanka used encrypted apps and maybe a separate phone to talk about the money transfer. They think she avoided using regular work emails to keep things off the official records. Now, with these court orders, they can try to pull back those deleted conversations from company servers. The people close to the Trump family are worried. They thought the money path was hidden well. But they did not expect the government to go straight to the tech companies for private chats. The companies have a short time to hand over the information. If backups from iCloud or other places come through, even one message about moving money to keep it safe could change everything. It might turn this from a money dispute into something more serious, like claims of blocking justice, which could lead to bigger problems. This $45 million transfer started the trouble for Ivanka. The monitor noticed money moving from a family trust to her new Delaware company. This raised questions about whether it was done to hide assets from a court judgment. To prove someone did something wrong on purpose, you need more than just odd timing or missing papers. You need to show they knew it was not right and planned it that way. That is why messages matter so much. Texts, chats on encrypted apps, or talks with family, accountants, or lawyers can show what someone really intended. Documents about money can be explained in different ways, but private words are harder to change. Letitia James understood this. Instead of just asking for bank records, she went after digital conversations in a very direct way. This surprised the Trump legal team. Normally, in civil cases, asking for electronic info takes a long time. People share what they want, lawyers argue about what is fair, and it can go on for months. But this time, James asked for emergency access. She said Ivanka used secret apps to avoid leaving tracks. If they waited for normal steps, more evidence could disappear. The judge, who already found fraud in the main case, agreed. He gave permission for wide requests to get messages from phones and apps during that key time. The companies must follow the court order. Ivanka's team has little chance to stop it quickly. Prosecutors want to find proof that she knew the transfer was to protect money from being taken by the court. For example, a message like, "We need to move this cash before they grab it," or talks about setting up the company fast would show real intent. Using encrypted apps and a possible extra phone makes it look like she wanted to keep things separate. People do not usually do that for normal business. It suggests they worried about others seeing it. That alone can be used as evidence of knowing something was wrong. Modern tech makes it hard to really delete things. When you erase a message on your phone, it often stays on company servers, in cloud backups, or in logs that show when it was sent. Apple's iCloud saves a lot of phone data by default. Phone companies keep records of texts and calls. Even Signal and WhatsApp, known for privacy, have some info on servers that courts can get with the right order. Experts can put together pieces from different places to rebuild conversations. Deleted does not always mean gone forever. Ivanka's lawyers are probably very concerned right now. They do not know what messages exist because they were not in those chats. Ivanka might not remember every word from months ago. Something said casually could look bad in court. The request to Apple is especially tough. iCloud backs up almost everything if it is turned on. Even deleted messages can be in old backups. Apple follows valid court orders and hands over what is asked. They cannot ignore it. For Signal and WhatsApp, messages are encrypted so companies cannot read them easily. But if backups go to iCloud, Apple can access those copies. Also, if the other person in the chat did not delete their side, that copy might still exist. Even without full words, patterns like who talked when and how often can show planning together. This kind of digital search is scary for anyone who thought their private chats were safe. Investigators can use small bits of data, like logs or backup pieces, to rebuild what happened. Ivanka's team knows underestimating this can ruin a defense. The companies have deadlines to respond. They usually do it quickly to avoid their own legal issues. Soon, prosecutors could have a lot of data to review. Ivanka's lawyers are trying to fight back with motions to stop or limit it. They talk about privacy rights and protecting lawyer talks. But courts often allow this when there is suspicion of hiding evidence. This puts a lot of pressure on Ivanka. Even before any messages come out, knowing they might is stressful. Her team has to think about what could be in there and whether fighting is worth the risk or if settling is better. The real danger is if private messages do not match what Ivanka says in public. Officially, through her lawyers, she says the $45 million move was just normal business planning, not connected to any court judgment. But in private chats she thought were gone, she might have said something else. Like admitting it was to keep money safe or talking about quick setup to avoid problems. If those words come out, it could prove the public story is not true. That is how many cases get won, by showing someone hid their real plan. Right now, this is a civil matter about money and business rules. The worst could be paying back funds, fines, or limits on business. But if messages show she deleted things on purpose after knowing about the case, it could become a criminal issue like obstruction. That carries possible jail time. Suddenly, it is not just about money, it is about personal freedom. Her lawyers are in a tough spot. A civil case can often be settled with payment. A criminal one changes everything. They know stories of other big cases where deleted emails or app chats came back to hurt people. Business leaders, politicians, many learned that digital proof is strong and hard to argue against. Ivanka's team is making arguments to block the requests. They say it violates privacy rules, goes too far, or includes protected talks with lawyers. These points sound good in theory. But in practice, courts often say no when there is evidence of possible wrongdoing. Privacy does not cover using communication to break rules. Lawyer protection does not apply if advice helps fraud. Even the idea of this happening puts pressure on her to maybe agree to a deal before things get public. Her lawyers likely ask her what she remembers saying. They discuss risks of fighting versus settling quietly. If messages do come out, it will be big news. Court files become public. Media shows screenshots. Private words spread fast online. Even without criminal charges, it could hurt her image a lot. The public sees what she said when she thought no one was watching. The tech companies do not take sides. Apple, phone providers, Signal, WhatsApp, they follow court orders because they have to. Their rules say they cooperate with legal demands. They promised users privacy, but always noted exceptions for court requests. Relying only on encryption for total safety misses how the law works. Watch the next few weeks. If motions to stop fail, data comes soon. Prosecutors review it carefully. They decide if it shows more fraud, obstruction, or enough for stronger claims. Then options appear, more charges, or perhaps a settlement to end it. This case could change things for others. If this kind of strong digital search works in civil cases, it becomes a new tool. People might think twice about using encrypted apps or extra phones for sensitive talks. They will know backups and logs can bring things back. Wealthy people facing lawsuits may realize digital privacy has limits when courts get involved. Ivanka cannot change past messages. She cannot make Apple ignore the order. All she can do is wait and hope her team's arguments work or the messages are not as bad as feared. Not knowing what will come out is hard. It creates stress because you cannot prepare fully until you see the evidence. Something will happen soon. Companies will follow the order or face penalties. Lawyers will win a delay or see the data released. Ivanka might settle to avoid exposure or face whatever comes from those old chats. In today's world, with cloud storage and company records, deleting something on your device does not erase it everywhere. Traces remain on servers. When authorities have court power, they can find them. This shows that private digital talks are not as hidden as people think, especially in legal fights. The pressure is high. Every day, without blocking the requests, brings the evidence closer. The legal team knows time is short. Ivanka faces a moment where past words could decide a lot. The idea that nothing truly disappears online is becoming clearer. For her, that lesson might come at a high cost. This situation reminds everyone to be careful with digital communication. What you type in private can become very public if a court wants it. Privacy tools help, but they do not stop valid legal orders. In high-stakes cases, those orders can reach deep into personal data. For now, the story is still unfolding. The subpoenas are active. Compliance deadlines approach. The outcome could affect not just Ivanka, but how similar cases handle digital evidence in the future. People will watch closely to see what happens next.